What's up, everybody? Welcome into another episode of The Lawyer You Know. Today was a jam-packed day of witnesses for the defense and arguments made by lawyers who continue to fight for their client, regardless of what the rulings are, what the other lawyers are doing, what happens with some mistakes or potential more material misrepresentations, some surprises in court, some things we've never heard before, which is pretty amazing in a case like this, which is followed so closely, and all these motion hearings and a prior trial has happened, and yet still new information is coming out. I wasn't planning on being live, so be ready for a little bit of a different video today than you're used to, and I'm going to need your help, everybody in the comments, for when things happen in this video to remind other people what's going on, because it is just different than we normally have, but I'm pumped to be able to have at least a little bit of time with you guys. Hit that like button. Make sure you are subscribed to our channel. Let's get to it. So what's different about this video, Peter? Let me answer that question for you. I am going to a concert at 4:30. I have a hard out that is 33 minutes from right now, this second. And I already recorded the first half of the day up until lunch today. I was planning on recording after lunch right now, but I figured court ended a little early. Let's just go live so I can answer your questions. So what I'm going to do is I'm going to talk about Dr. Wrenchler right now. We're going to do him first, which is kind of backwards for the day. And then I'm going to play my part one after during this stream for you guys to watch and interact with, obviously, with each other. But this first 30 minutes, we're going to do Wrenchler, and I'm going to answer your questions. So get as many questions as you can in. Kelsey's going to star a bunch of the questions. John's going to star a bunch of the questions. So I want to answer as many as I can here. I will not be able to answer questions after 4:30. So people are going to probably be asking questions. If you as the chat could remind them that it is no longer live once we're past 4:30, I'll be wearing the same thing. It should be pretty obvious, though. This is a live. It's not a premiere. I apologize for the confusion, but I thought it was still fun to hang out and talk about it for 30 minutes is better than 0 minutes on a day like today. And I will also play that. It'll have an intro and everything. So it won't make a lot of sense, but who cares? We're here to talk about the case, and I really want to answer your questions. I'm sure you have a ton. You do not have to limit your questions to Wrenchler. I will answer your questions on anything you guys bring up. We are just going to jump into Wrenchler. I will say one thing about Dr. Laposada. Right before I broke on part one, I was like, ooh, that's some pretty good impeachment material that Brennan has on her. I thought it fell completely flat. I thought he was going to crush her credibility, but he didn't. What concert everybody's asking? Post Malone and Jelly Roll. I don't know why. My wife got the tickets. One of my buddies, it was his birthday. He wanted some of us to come with, and it was going to be just a girls thing. Turned into all of us. We're taking the Sprinter van all the way to Orlando and back tonight. So it'll be fun. So I'm looking forward to that. I'll send you some videos, or I'll post some stuff on social media if you want to give us a follow on there. Lawyer You Know on Twitter, Tragos Law on Instagram. All right, let's get to it here, folks. Let's get Wrenchler up on the stand. They go through, he's a biomechanist, great background experience. He talked about some hockey stuff, which I assume people in Boston care about. Some of the things that he mentioned, working for the government, really good resume. But I thought it was really important how Jackson got out early on. What is your specialty? What is your field? What are you an expert in? And to me, incredibly important, because nobody else is really an expert in this, and nobody else can answer these questions for the jury, but Dr. Wrenchler can.
Kinematics is one of the specialties, yes, sir.
Fancy word. Probably nobody knows. I didn't know it before I met some of the folks involved in this case. What does kinematics mean?
Kinematics is just motion of the human body. So it's looking at how the body moves in different situations. Whether you're in a vehicle and it hits a wall, how does your body move? It moves forward. Will it load into the seatbelt? Does the airbag deploy? Or if you're a pedestrian and you're struck by a car, how does the body move as a result of that interaction? That allows us to look at the loading to the body. Forces are exerted on someone's body because their body's loaded by different objects or different forces. So kinematics is one of the first steps. If you're going to look at injury causation, you have to determine the kinematics of an event.
What are human tolerances?
Human tolerance is really just looking at how much force it takes to cause an injury. So there's been generations of testing to look at different forces. For instance, the humerus, the upper bone in your upper arm. How much force does it take to cause that fracture? They've tested the cadaver bones. There's a lot of research for decades out there looking at different parts of the body, the ulna, the radius, the two bones in your forearm, skull fractures. Almost any type of injury, again, has an injury mechanism. And in order to determine how it occurs, we have to look at tolerance. How much force can the body withstand before you start to see a specific injury occur?
Before it breaks. How much force can the body withstand before it breaks? That's what his specialty is. That's what his experience is. That's what his, that's why he is an expert. Peter, why do you think they struck out the video with Laposada? So I was listening, not watching. What video were they showing? Was it Welcher with the blue paint? Is that the video? Before I answer this question, let me know in the chat if that's the video. If it was that video, even though it was going to disagree with some of what she said, Hank Brennan's the one that said she's not an accident reconstructionist. Hank Brennan's the one that said she can't testify about the taillight shattering. Hank Brennan's the one that said she can't testify about all this stuff. Oh, it was the Randy video. So again, same difference. If it's the Randy video, anything that has to do with the accident reconstructionists, the defense has experts on that. You can ask them about it. Hank Brennan did not want her to be allowed to testify to that stuff, and now he's going to try to ask her about it and impeach her on it. If he did, I reckon the defense should have been able to, that should have left the door open, and the defense should have been able to ask her all the accident reconstructionist questions then. So be careful what you wish for if you're Hank Brennan. Okay. Then we get to kind of why he was retained initially and what he was asked to do initially and who retained him initially. Why does Jackson have to edit all these slides for ARCA? There's hearsay. There's inadmissible information on there. The judges ruled they can't come in. I don't understand why they say that. Like, maybe I miss it, but like if I'm allowed to put in PowerPoints, which I'm not always allowed to put in PowerPoints, I don't know why you can't put an expert's conclusion in a PowerPoint. For visual learners, it aids the jury. She was like, no, it doesn't aid the jury. We got to give the jury more credit, as if Miss Little was being disrespectful to the jury, when in reality, she's like, no, it just makes it easier. Some are audible learners, some are visual learners. Let's put it up on the screen for them. Judge Cannoni didn't allow it. When the judge makes rulings like that, well, you have to edit the slides. I have not seen if they ruled on the missing witness motion, but I've heard the defense is no longer asking for the third-party culprit instruction, which I find interesting, and I don't think I hate it. I don't think I hate it. More on that in the recorded video that I did. I'm going to tease my own video coming later. But let's talk about now kind of the scope initially and who he was initially hired by, which some people said maybe the defense wouldn't get into. I thought they should. I think it comes across well every time they talk about it.
Participated either yourself or colleagues?
Probably 10 or 12 papers and then some abstracts and I believe a book chapter as well.
Have you been qualified in other courts to testify as an expert in the area of biomechanics and accident reconstruction?
I have, yes.
Approximately how many times?
Oh, I've testified throughout my career probably over 150 times in both state and federal courts throughout the country.
I want to talk to you for a second, Dr. Wrenchler, about how you began working on this particular case this before the bench. When were you initially retained in connection with this case?
We were initially retained. I believe it was for the first trial. It was, I believe.
It's like, oops, so many people have said the first trial. By the way, I'm going to ask a little earlier than I usually do. Everybody hit that like button so we can get everybody in here to ask their questions here in the next 26 minutes so I can answer as many as I possibly can before I have to run to the concert. Do you think Judge Cannoni was being difficult because the defense could have objected to the sweatshirt at the time versus the motion to dismiss? They could have, but a lot of things are going on in trial, and there's got to be some trust between the lawyers that lawyers are not going to materially misrepresent facts and just be dead wrong on things. So while they were not incredibly timely, or you could say they were a little bit late, they did it as soon as they realized it, and they probably wanted to confirm before they accused Hank Brennan of something like that, and sometimes it takes a second to confirm.
Maybe it was the fall prior to that actual trial. That was last year.
All right. When you were, by the way, initially, were you hired by the defense?
No, we were not.
Were you hired by the Commonwealth?
We were not, no.
Was that a separate agency that hired you?
It was, yes.
It wasn't an insurance company, was it?
It was not, no, sir.
Okay.
That felt like somebody whispered to him, not an insurance company. So they knocked that out. Separate agency, not defense, not Commonwealth, not an insurance agency. And eventually he says all of your findings were turned over to both the Commonwealth and the defense, right? How about that?
What were you initially asked to do by the separate entity?
Initially, we were asked,
So it's really funny, your guys' comments about Laposada during Brennan's cross. Seems like we saw things the same way. I was like, she smashed him a couple times on cross.
Constrained in what we were asked to do and to review, but we were.
Was it?
It was not, no, sir.
Okay. What were you initially asked to do by the separate entity?
Initially, we were kind of constrained in what we were asked to do and to review, but we were asked to evaluate whether the injuries sustained by Mr. O'Keefe were consistent with being struck by the Lexus.
And who at ARCA was assigned on the team to undertake this commission?
There was myself, Dr. Dan Wolf, and I believe Mr. Scott Klein was another engineer who was involved.
And did all three of you join in the analysis that ultimately ended up in a report that you authored, or the three of you authored together?
We did, yes, sir.
What materials did you review in furtherance of your initial consultation in this matter?
Obviously, I looked at the medical records. We looked at photographs of the vehicles, information about the vehicle, photographs of the actual incident scene, various information pertaining to the Lexus itself.
You know who Dr. Dan Wolf is?
I do, yes.
Is that the other person, the Dan Wolf, the Dr. Wolf that you just mentioned?
That's correct, yes.
Did you and Dr. Wolf look at basically the same set of information? You were provided the same set of information?
We did, yes. We were provided a tranche of information that all three of us looked at, yes.
Can you explain the difference between your area of expertise and Dr. Wolf's area of expertise? I don't want you to get into his analysis, just what area he covers. In other words, you're dealing with a Lexus and pedestrian, right?
Correct, yes.
What's the
So the Dr. Wolf already kind of talked about that. I see a lot of people talking about Hank Brennan getting into the credibility issues of Dr. Laposada. And that's something I didn't really get to hit on part one very much because I actually thought it was a lot of pretty damning stuff that could make her look really bad depending on how it was presented. And I can understand how people didn't like her depending on how it was presented. But she basically had great answers for it and was like, it was all BS. And none of it was true and it was unfounded. And she explained how, and she got a new boss and he wanted to cut budget and she wouldn't sacrifice quality for time. I mean, she handled it beautifully. It sounded like, because she had a really great resume. Then when Brendan was arguing, I was like, oh boy, maybe he's going to be able to hit her. I said, I would have started with that instead of all the other stuff he started with that really didn't work. And instead, it really didn't crush her credibility like I thought. And then everybody's going to like the fact that Brennan has used Dr. Laposada. And that's when you really have to be careful, because I have used experts that are most of the time defense experts or vice versa. And I have attacked experts that I've also used, but you have to attack them the right way. And how I attack them is you mostly testify for the defense. This defense team has paid you $3 million to do this. And isn't it so common that this is in your report and you just basically copy and paste this conclusion? None of that brings up the relevance that I've hired him, right? He still has made $3 million for the defense over the last 3 years. And usually judges don't let him get into, oh, they've hired you. But if they do, I don't care. So absolutely things used versus hired, whatever. But when you're trying to say they're a hack and you crush their credibility the way Hank Brennan did, then sometimes it looks worse, the fact that you, in fact, have also used this witness that you're saying is a hack. Ugo Monk, thank you for taking some time to go live today. You are the first person I look for as soon as court ends. We appreciate you. Have a bottle of water at the concert on me. Isn't that funny? Yeah, it probably is going to be a $20 bottle of water. I'm going to be buying it for a few people. So thank you so much for that. Ashley, well, it didn't hit him, so it doesn't matter. I'm sorry. Can't stop hearing it. Are you coming to Boston? I need to plan ahead. Oh, yeah. I've got a lot of thoughts on that in the video that I recorded that we're going to play here in a second. Think I'll go to Boston. No, I don't have any plans to be in Boston anytime soon. Dr. L was amazing against Hank. He failed. Almost lost my mind when I saw the x-rays after Dr. We don't know if there were fractures because there were no x-rays. Did I hallucinate that? I called it a jaw-dropping moment, honestly. Like, my jaw hit the floor and I was like, I mean, we should have known. It's like, duh, they did x-rays. It would make sense that they did x-rays, but we all just assumed that they were being honest. And that's another moment the defense didn't immediately attack. And I just have to believe that's evidence of there's just so much going on that it's hard to keep track of. Please explain to your followers why the state will never ask for a mistrial. Lots are saying Hank is going to be requesting a mistrial. I hope he would be that dumb for a motion for mistrial. So here's what I'll say. I won't say the state will never ask for a mistrial, but very rarely, because if the mistrial is at any reason their fault, they can't refile. But there are scenarios where the state will ask for a mistrial if there is misrepresentations and unethical conduct by the defense attorneys that has poisoned the jury. They have to redo it. And sometimes it can even be the cost can be taxed against the criminal defendant. I have seen that happen before. Do you think Dr. Wolf now knows the truth about the holes in the back of the hoodie, or is he still sequestered? It's a good question. I don't know if he knows it or not. If he's been released, he's not under the rule of sequestration anymore. I just thought he did a good job answering them when you don't know. And they're still inconsistent because they were in fact cut. So that's not consistent with the taillight or road rash. He answered it correctly as far as I'm concerned. All right, next we're going to jump into, he talks about the supervisual abrasions, the head injury and the arm injury of John O'Keefe. And I really like how Jackson separated Dr. Wrenchler, don't call me Welcher, his testimony, where they were able to basically completely contain and talk about everything he did in the first trial or before the first trial right now, and the jury gets to hear these really good opinions. But they get to be left with a little carrot. he's done more testing. And he's done that testing after he looked at what Wrenchler and Aperture did, and they get to hear that rebuttal to the Commonwealth's theories tomorrow morning. And I'm looking forward to it. I don't know about you guys, but let's first hear what his opinions were prior to the first trial when he was hired by this other agency that's not an insurance company, not the defense, not the insurance, not anybody associated with either side. What were his opinions when he looked at all the evidence and he went through everything he looked at? Let's take a listen.
Applied at the back of the skull to actually cause a fracture like that. The abrasion, superficial abrasions, and an abrasion is basically rubbing or scraping or friction that kind of scrapes away the top part of your skin, the epidermis. You have the epidermis, the dermis, and then the hypodermis. An abrasion is just gets into the top epidermis and doesn't get any farther. Laceration is an actual tearing or ripping of the skin, usually down past the epidermis into the dermis. And so that takes either a blunt object or a sharp edge, depending on whether it's an incision or laceration, to actually produce that type of an injury.
Did you look at patterns of injuries on Mr. O'Keefe?
Yes.
Did you also, the other side of that handshake, did you also look at damage to the vehicle, physical damage to the Lexus?
We did, yes. Our goal.
So you got to look at both the injuries to John O'Keefe and the damage to the Lexus, not one or the other.
Or what we were tasked with was to determine whether the injuries are consistent with the damage to the car. So clearly, you look at how these injuries are created, what injury mechanism you need to produce them, and then you look at the damage to the car. Can you line up contact between where those injuries occurred and how they occurred with damage to the vehicle?
Which you should be able to do. If he's hit by a vehicle and the vehicle made those scratches, it should be pretty easy to line all this up and see how it works. It shouldn't be this hard, folks. If you're new to watching court cases, if you're new to car accidents and pedestrian accidents and how these injuries occur and what they look like, this is not it. It is not usually this difficult.
What kind of materials did you review? In addition to, I'm guessing, photographs?
Photographs, yes, autopsy photographs, as well as photographs of the vehicle and the damage to the Lexus.
What about medical records, hospital records, things of that nature?
Absolutely. That's the first step, looking at the injuries to find what the injuries are, what are the diagnosed injuries, as well as it's important to determine what injuries don't exist, because that's also helpful in determining whether certain impacts may or may not have actually occurred.
Did you receive a full file from the medical examiner's office in this case?
I did, yes, sir.
Did you also receive police reports, follow-up reports, witness statements, things of that nature in this case?
We did, yes.
Did you receive any data concerning the vehicle itself, contained either in police reports or follow-up reports or expert reports?
We did, yes.
Mr. Jackson, I'm just going to ask you to slow down the cadence of your voice a little bit.
He has a tendency to do that, to try to get through it. Mary said, I thought Hank was very respectful towards her, and she was outstanding. She kept circling back to, not in this case. I think he went easy on her in case he needs her in the future. So that's an interesting take on it. And again, I'm going to be repeating myself later because I agree with you. I was surprised with all of the impeachment material he had against her, how he wasn't more snarky, how, he wasn't able to get into that another court had called her a hired gun. But once he said that in my mind, I'll just tell you how this stuff works. Once he said that, when I started listening to her after versus how I felt about her before, I was like, ooh, she really is pushing for the defense, which a lot of the defense witnesses haven't. She was strong in doing everything she could to slip in something good for the defense. And that's a witness that feels like they have a little bit of an interest in the case. A lot of the defense witnesses, I don't feel like have been like that, but she has. And I don't know if it's because I heard Hank Brennan say another tribunal, another case was like, you certainly seem like a hired gun. I'm not sure how credible you are. That makes a difference to me. Jury never heard it.
It's late in the day and I'm doing it again, aren't I? I'll slow down. I forgot where I left off, but let me ask you sort of openly, was there anything else that you considered and analyzed in at least building a database from which you would build an analysis?
Well, yeah, I mean, we review all the materials that are provided to look at all the injuries, to look at all aspects of the vehicle, damage to the vehicle, information about what the vehicle may have been doing.
Michelle, he's done that multiple times where he's like, Judge, they cannot talk about this, and then asks him about it. It's very weird.
Any other evidence that may help contribute to looking at what either caused the injuries or what may or may not have caused the damage to that vehicle.
When you and your teammates undertook this analysis, did you even know who we were?
Initially, we did not. No, initially, I personally didn't know anything about the case. And we were asked not to do any research or to look up anything about it. We were given certain parameters, certain information, and that was it.
Again, I think me and my dad disagreed about this. Maybe me and Bedero. I think that came off great. I think asking them about their unbiased nature prior to the first trial, that it was somebody not connected with either side, and that they were told to not look up information in the case. That is so different, folks, than any other expert or witness in this entire trial. And when you have something like that, use it. It's so rare to get it. The defense attorneys tried to use it. I completely agree with it, and I think it came off really well. Mitsame, Peter, do you know if Wrenchler would still be under oath between the case in chief and rebuttal, or can Brennan speak with him before his rebuttal testimony? He's not supposed to speak with him before his rebuttal testimony because they know he's coming back. He is still sequestered. He can talk to him. He can talk to him as far as like, this is what we're going to talk to on rebuttal. And I mean, in most cases, he'd be allowed to watch this because he's going to rebut this testimony. So he should be able to watch it. But it seemed like they had the experts under the sequestration order. Usually we don't put our experts under the sequestration order. So I don't really know. Defense will bring up the x-rays on Wrenchler's rebuttal. Oh, you think? I sure hope they do. Dr. Wrenchler, remember when you said these don't exist? I also have some thoughts on that in the video that's going to come, so stick around for that.
Did you follow those instructions?
I did, yes.
The undertaking, the analysis that you did, was it in keeping with the accepted methodology or methodologies in your field of engineering?
It was, yes.
Did you ultimately reach some opinions and conclusions based on that initial investigation or analysis?
I did, and we did it at ARCA, yes. Myself, Dr. Wolf, and Mr. Klein did.
Did you reach any opinions or conclusions with regard to the force required to produce the occipital skull fracture that you noted with Mr. O'Keefe, his head being struck by the rear tail lamp of the subject Lexus?
I did, yes.
Tell me what those opinions and conclusions were.
Well, again, we determined by looking at research.
So now he's going to get into what were your conclusions after round one. What do you think of the fire exchange this morning between AJ doesn't put up with HB and Bev's? Also, Dr. Laposada's clapbacks on cross, Sassy Queen. Ooh, I had some thoughts on that. And I think you can start to tell Hank Brennan is not as jolly and confident as he once was, and he's starting to get very frustrated with what's happening in the courtroom. Is it possible that Hank prepped Dr. L on how to handle cross-examination attacks when he hired her previously? Very ironic. If so, it could be. Ashley, did Hank even ask her how much the defense paid her? I didn't hear it. He said, you're paid for your time. He did not ask the amount. To me, that always indicates the amount's probably not that much, but he wants to say she's biased because she was paid. I think Brennan just wanted to get into her credibility issues for the headlines and publicity, never intending to really dive in during cross. Well, man, it's pretty good fodder for cross and didn't crush her, I didn't think.
Search and tolerance values that would take about 1,400 to 1,600 pounds of force to cause an occipital skull fracture. Now, we were tasked with looking at, again, could that result from impact of the car? So one of the things we did is we took a head from a dummy basically that's instrumented with accelerometers, and we dropped it onto a taillight cover to attain a speed of 15 miles an hour. And so that would be comparable to the vehicle striking the head at 15 miles an hour. And I concluded a few things from that. A, that the force wasn't sufficient, or the acceleration wasn't sufficient to produce enough force to cause a skull fracture at 15 miles an hour. And also, when you look at the position and configuration of the occupant, it really wasn't possible to get a skull fracture by hitting the taillight and not sustain any other significant fractures. For instance, where the taillight's positioned to have an impact to the back of the head, you really couldn't have someone positioned in such a manner to strike just the head and not have subsequent concomitant injury to the neck.
If you did, it would be obvious to the head injury, right? If your head was sticking out and you were down tying your shoe and the car came and the bumper just hit you in the head going 25 miles an hour, that would be incredibly obvious to the damage done to your head and the bumper. That's the point.
Or any other part of the body. So my findings with respect to the skull or the occipital skull fractures was that it likely did not occur as a result of contact, specifically with the taillight cover on the rear passenger side of the Lexus.
So as to the question of whether Mr. O'Keefe suffered the occipital skull fracture as a result of being hit by the tail lamp at 15 miles an hour, were you able to scientifically rule that out?
I was, yes, sir.
Was that to a reasonable degree of scientific certainty?
It was, yes.
Did you reach any opinions or conclusions regarding the abrasions on the right arm that you noted earlier on Mr. O'Keefe's body?
Yes, I believe my conclusions with respect to the abrasions are that it was inconsistent with contact to the taillight, and that not only that those injuries are inconsistent, but you would expect additional injuries, likely fractures to the hand and or the forearm, depending on the actual speed of the vehicle.
Other than the expectation that you would see fractures or other damage to the arm, what was the basis for your opinion that the linear abrasions would not result from impact with a non-damaged taillight traveling in reverse?
What you have to look at.
All right, before we get to the arm injury, which is kind of the main point, Gen V said, how could she have hit the back of his head and nothing else? That doesn't make sense. I agree, but this is from the first trial where the defense wasn't sure exactly what they were going to say or what their theory was going to be. The Commonwealth is not arguing for sure that that's what happened this trial at all, but that's what Wrenchler tested. That's what he came up with before the first trial. Hank seems to be running that courtroom. And thoughts on Hank's outburst at Alan Jackson. Here's what I'll tell you about Hank Brennan at this point. Most of the time, you guys get annoyed. I give lawyers the benefit of the doubt when they say, this witness said this, or we have this, judge. I believe they have it, and I believe the document or the piece of evidence is what they say it is generally, unless they are proven wrong. And I feel like at this point, Hank Brennan has been proven wrong too many times for me to give him that benefit of the doubt. So a lot of times I'm going to have to be like, I'll believe it when I see it, which sometimes when people email me stuff and they're like, oh, I know what happened, this person told me, I'm like, oh, I'll kind of believe it when I see it or when it's actually borne out. Feels like Hank Brennan's entering that territory for me at this point because it's just happened too many times. Bat Mama, Peter, can you give me your top 3 to 5 things that the jury can use to prove her innocence and your top 3 to 5 things the jury might use to vote guilty? So the top 3 to 5 things about innocence are the damage to the car does not line up with these injuries. The injuries to him does not line up with getting hit by a car, and too many problems in the investigation, the way it was set up, the way it was secured, the chain of custody, the glass that ended up where it ended up, the text messages, the fact that Proctor got terminated for them. Those are the 3 big ones. I mean, it feels like more than 3. The 3 reasons why they would think she was guilty: she's drunk, she's driving the car, she and John O'Keefe are at 34 Fairview in the vicinity of where his body was found. That's what I would say. It's kind of how I'd answer those 2 questions. I feel like she said she just received the x-rays last week. Am I wrong? I don't remember if I heard that. Kathy P, as an auditor, I can tell you if Dr. L's office was in the process of changing their procedures, a third-party auditor will still write the non-conformity because they have bosses too. Peter, I watched an old Turtle Boy video with Ronnie the juror. He worked with the defense this time on why 8 people voted manslaughter. It was about the injuries. Interesting. He's helping the defense. That's interesting. All right. So now let's get Wrenchler's opinion on the arm abrasions. 7 minutes till I'm not going to be live anymore, but I still have all my thoughts on what happened in court today.
Impact with a non-damaged taillight traveling in reverse.
What you have to look at the kinematics associated with that, and that in order to get just superficial abrasions, that doesn't take a significant amount of force, but essentially that to have an arm contact the rear of the car, and we weren't really given any theory of how the arm contacted the car. So initially, we weren't privy to any theories or allegations of how this may have occurred. So just generally speaking, look.
Everybody's saying she received them a couple weeks ago, which is even more interesting that the defense chose not to cross Welcher on him at that point. So maybe they won't cross him on him in rebuttal. But man, I thought that was really, I really hope, because here's the point as a lawyer, why I usually don't say things. You never know when a juror is going to make up their mind. And hopefully they didn't make up their mind when they're like, we can't believe the fractures. Although if they did, pretty sure their mind was changed now that there are x-rays proving no fractures. And so much more than no fractures, right? No swelling even. But I break that down in detail here soon.
Looking at the arm, how it would contact the car, and subsequent movement and interaction with the light cover, my opinion was that the injuries would be inconsistent, or the injuries that Mr. O'Keefe sustained on his right arm and didn't sustain would be inconsistent with actual interaction with the taillight.
Doctor, were your opinions and conclusions, along with those of your colleagues, reduced to a report?
They were, yes, sir.
Was that report, to your knowledge, ultimately turned over to both the defense and the Commonwealth in this case?
To my knowledge, it was, yes, sir.
I'm going to change gears for a second and bring us forward to the spring of 2024, after February.
So, inconsistent with being hit by a car / taillight. Kevin said, Peter, Malone and Jelly Roll, my faith in you and your integrity will never waver, but instead of being 100, it's now 99.9%. And on top of it, I blame your wife. So I will just tell you, have that right. I love my wife very, very much. I like some Jelly Roll songs and some Post Malone songs as much as the next guy. I'm not a huge concert guy, but my wife wants to do it. I want to do it. I'm going to do it. So we're going to do it. We're going to go see Jelly Roll tonight and Post Malone. The streets say Papa George is a huge Jelly Roll fan. I'm 99% sure he does not know who Jelly Roll is. Jessica, can the defense talk about the multiple misrepresentations by the Commonwealth in closing? Might limit Hank's closing to address it. They can talk about the holes and things like that. They can talk about Wrenchler just being dead wrong and not having the information of the x-rays, but I don't think they're going to be able to call them multiple material misrepresentations by the Commonwealth. I don't think the judge will allow it to go that far.
After February of
So now he's going to set up what he did on this trial.
2024, moving into the start of 2025. Did the defense at some point reach out to ARCA and contact you and Dr. Wolf?
They did, yes.
That was back in 2024 after the spring, correct?
That's correct, yes.
At some point, did the defense engage you specifically to testify?
Yes.
This year?
This year?
This year, meaning
Yes.
this trial?
For this trial, yes.
Okay.
Yes, correct.
Were you asked to conduct further testing in furtherance of your potential testimony in this trial?
We were, yes, sir.
And were you provided additional materials from the defense in furtherance of your potential testimony and your testing?
We were, yes, we were provided additional material with respect to, yes, the theory of how this may have occurred and how Mr. O'Keefe may have sustained his injuries, allegedly.
So again, they're setting it up now. So that's everything he did before, but what's coming next? And I love the way Jackson did this. And I'm just going to tell you, I got 3 minutes left. So if you want me to answer a super chat question, stop sending it. Don't send anymore. Fair warning. Let everybody know if you want to give super chats or send them in. We're still going to put them up on the screen as I play the rest of the video, me breaking down the rest of court. But I just want to give everybody a fair warning here. Wouldn't withholding the x-rays until 2 weeks ago be a Brady violation? They've had them for years. Yes, it would be, but I don't know if that's what happened. I have not seen any documentation or heard argument in court that the Commonwealth had these and withheld them from the defense. I don't know how or when they got them or when the defense knew about them, so I can't really dive into that too much. Peter, do you see some strategy Hank is using to slow down the defense momentum with the experts being in front of the jury for all these motions filed that disrupt their testimonies? It's possible, but I really think Hank Brennan's motive is, I want to cut out as much of this defense as I can. It didn't hit him, so it doesn't matter. Brennan couldn't shake her. The defense's case in chief is coming together nicely. How do you feel any different about not calling Proctor after today's testimony? Izzy, this is such a great transition into the video that you're going to watch and my thoughts on it, because I break it down in detail, what I think about what I thought was so important before and what I thought the defense can do and how that may have changed once I've heard all this testimony. You already thought the decision yesterday regarding, actually, I'm going to hold that. Your wife trained you right. Well, I love her. I love her. Hey, Peter, could the defense bring in the findings, firing report on Proctor without bringing him in? I don't think they can bring all that in without actually calling Proctor. Post is from my hometown, Phoenix, New York. Have a blast. He puts on a great show. Well, good. That makes me feel better. AJ told Bev the ruling is outrageous and she folded. So many thoughts on this. I'm going to play the last thing from Wrenchler here, and then I'm going to use a comment to transition us into the first thing I talk about, and it has to do with this entire motion. Jackson Handel, we listened to his entire argument. I thought it was a chef's kiss, some of the best lawyering we've seen so far.
Included in the materials that you were provided.
Mr. O'Keefe may have sustained his injuries, allegedly.
Included in the materials that you were provided in anticipation of your testimony in this case, in this trial. Were you provided anything from a company called Aperture?
We were, yes.
What were you provided from Aperture?
We were provided a written report from Aperture, a PowerPoint presentation, about 140 some pages from Aperture, and then a file material, I believe, what was reviewed and the results of some testing that Aperture had conducted with respect to this case.
Was it your understanding that the Aperture PowerPoint was authored by a particular individual?
Yes, sir.
Who authored that PowerPoint as far as you knew it?
As far as I'm aware, it was Dr. Judson Wrenchler.
Your Honor, may we approach briefly?
Okay.
And that was the end of court for today, setting up exactly what he's going to do tomorrow. Okay, Eldon said, you already thought the decision yesterday regarding Laposada wasn't good, but what did you think of the decision today for reconsideration was worse? Let's take a listen to those entire arguments, everything that they discussed, the arguments made by both lawyers. I break it down, things we thought were true, but it turns out. Okay, so this is a video of myself. This feels like a bit of an inception moment, but this is when we're going to go to the pre-recorded video that I did for everything that happened in court today. Make sure you guys Throw your questions up there, throw whatever you have, comments, everything. But it is a premiere at this point. We're kind of transitioning from the live. I want to make sure everybody knows that. I love you all. Hit that like button, please. Yes, I have to get on the road like the last comment said because there's so much traffic, but I wanted to break everything down with you. So make sure you guys stick around. Tell me what you think. I'm going to come back. And actually, while I'm driving, I'm going to try to get into the live. I'm not driving. I'm going to be sitting in the Sprinter van in the back. Don't worry. I'm going to try to follow the live chat. I'm going to try to answer your questions in the live chat. So stick around, hang out. Let's get to it now. Peace. Oops, that's not what I wanted. What's up, everybody? Welcome back into the episode of The Lawyer. You know it's trial day 30 for Karen Read. More fireworks, more arguments made by the lawyers. Another expert takes the stand, and more shocking revelations of things we thought were true, but it turns out they were not true, either by some mistake or misrepresentation by maybe some lawyers, maybe some witnesses. We'll talk about what that means and so much more. Make sure you guys hit the like button. Let's get to it. So this is an absolutely crazy day for me. Whitney has scheduled a very fun night for us tonight. We are going to a concert, but we have to leave by 4:30. So I am recording part 1 here during the lunch break, and I will be recording part 2 right before we leave, literally right up until 4:30. Hopefully I get all of the content from court today, but I just couldn't miss a day talking about this trial with you guys. So we're here, and we're going to continue to talk about Karen Read, continue to answer your questions. A lot of them have already come through on Twitter as the day have gone. I've tweeted a couple times to see what questions everybody has about everything that's going on, and we started today with a bang. We knew that there were going to be arguments this morning. The judge had the jury show up late so that they could handle some of those arguments. We thought maybe they would talk about the jury instruction that was insufficient dealing with the holes in the back of John O'Keefe's sweatshirt. Turns out the judge is going to table that for the charge conference, which is fine. Hopefully the jury hasn't already made up their minds, and they will still listen to whatever instruction the judge hopefully correctly gives at that point. But we had a bigger issue, according to the defense, to deal with, and that is some of the issues with Dr. Laposada. And Attorney Jackson is the one making this argument, and he uses multiple catchphrases that we have said on this channel and have heard throughout this trial, such as grave concern, using something as a sword and shield, and of course the prosecution potentially burden shifting. So let's take a listen to this argument that, by the way, it is so incredibly difficult to research, do the research they do, compare what witnesses are saying at different times, reduce it to writing to give it to the judge, and orally make an argument like this while all preparing for a very intense 30-plus day trial, prepping witnesses every single night. But that is what these lawyers are doing. It is so incredibly difficult. That's why I say give them as much grace as you possibly can. I know they're professionals. They make a lot of money. It's a job that people expect a lot out of lawyers, and we get it, but it is difficult. And do not underestimate the amount of work it takes to get to this moment and to do this amount of work and to do it well. All right, let's listen to this.
We are asking the court to reconsider the court's ruling yesterday concerning Dr. Laposada and her ability to opine on the issue of dog bite and claw mark wounds and pattern recognition. We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. That is a problem. I brought it to the court's attention at sidebar. The court will probably remember that colloquy. It was not an open court, but I expressed grave concerns, to use that phrase, that there was a burden-shifting system that was going on when Mr. Brennan is asking our witnesses about, or his witnesses, about other witnesses that may be on the defense witness list and may be called. Obviously, as the court knows, foundationally, we don't have to call anybody. We don't intend to call anybody. We don't have to call anybody, but we can call whoever we feel like. But we shouldn't be put in a position where our hand is forced to call witnesses because of questioning by the Commonwealth, which is improper. After I brought it to the court's attention, Mr. Brennan has continued along that same line. The Commonwealth has continued along that same line, and I want to bring something to the court's attention specifically. Last night, we pulled the tape. Dr. Russell was cross-examined by Mr. Brennan on the issue, specifically, of Dr. Laposada and her opinions regarding dog bites.
And we remember this, right? Russell was like, oh, I'd love to hear her opinion. What did she say? Brennan brought it up and definitely was trying to get the jury to infer that they disagreed, that it was not the same. Now, Brennan's going to come up and give a little bit of a different angle as to where he was trying to go with that line of questioning. But Jackson makes a great point here. Brennan's the one that opened this door to Laposada discussing dog bites. And in fact, he kind of is trying to make the jury think something that we don't think is true. And now he's trying to block us from getting the truth out there and letting her talk about whether or not she thinks these are dog bites.
He asked questions over and over and over again. The colloquy probably lasted more than 5, 6, 7 minutes with Dr. Russell, specifically on the issue of whether or not she had seen Dr. Laposada's reports, whether she was aware of Dr. Laposada's opinions, implying that Dr. Laposada had opinions about the dog bites. She was asked if she was familiar with Dr. Laposada's credentials. Dr. Russell said, yes, she was familiar with Dr. Laposada by name, that she thought she had impeccable credentials, and she very much wished she could have seen her reports as it relates to dog bites. It was an intellectual curiosity by Dr. Russell that was evoked and elicited by Mr. Brennan on cross-examination of Dr. Russell. She was then asked the seminal question: did the defense, Dr. Russell, give you any reports by Dr. Laposada related to dog bites?
What page is that on?
On the transcript?
Yes.
Oh, my motion's back at the desk. I'll just read it. Question by Mr. Brennan to Dr. Russell. And so you think of all those forensic pathologists, medical examiners, you think that qualification and experience itself is not enough to qualify someone to give an opinion on a photograph about the genesis of a wound related to dog bites? Answer: well, if a forensic pathologist autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not sure that person would be a very good expert in that kind of case. Question by Mr. Brennan. Have you ever heard of a doctor named Laposada?
So are you going to read all 3 pages?
No.
So I've read it, Mr. Jackson.
I'd like to
So,
read it into the record, Your Honor.
it's in the record. I will put this transcript into the record. I'm not going to let you read 3 pages here.
It's not 3 pages, Your Honor. It's about another 5 lines.
The
It just
part
goes to
that
the
you
top of the
brought
next
to
page.
my attention is on page 15, not where you're reading.
Colloquy between between Dr. Russell and Mr. Brennan was specific to dog bite wounds. It was specific to Dr. Russell's understanding of whether or not Dr. Laposada had been retained by the defense, whether she was a defense expert, whether she had written a report, and whether she opined about dog bites and dog bite wounds. And after she was asked if she had been provided any reports by the defense attorneys specifically, from Dr. Laposada related to dog bite wounds, Dr. Russell said, no, I haven't been. And to summarize her statements, which the court has in front of it, Dr. Russell went on and said, I really wanted to see what Dr. Laposada had to say about these dog bite wounds. I really wanted to read her report, but no, I was never provided her report or reports by the defense. And of course, Your Honor, as the court knows, that is standard operating procedure. I don't trade reports between and among experts because obviously I want independent analysis. I don't want to cross-contaminate any opinions, et cetera, and be accused of doing so. So of course we didn't provide a report from Dr. Laposada to Dr. Russell. But Dr. Russell's intellectual curiosity was then extracted from the witness stand and the jurors heard all of that. So then days later, not weeks, not months, 3 days later, after eliciting testimony from Dr. Russell about Dr. Laposada having a report, being hired by the defense on the issue of dog bites and not providing that report to Dr. Russell, the Commonwealth then moves to exclude the very testimony that he was eliciting from Dr. Russell, leaving the jurors with a very, very deep and irremediable misimpression. They used it tactically as a sword and a shield, and that's burden shifting. That leaves the jury with the impression that Dr. Laposada was consulted by the defense, number 1, that she wrote a report, number 2, that the report was about dog bites, number 3, that she didn't provide that report to other experts, number 4, and the reason she didn't, obviously, is because her opinion, Dr. Laposada's opinion, would be harmful to the defense. That's the only reasonable interpretation of those facts.
And that's been the MO of the whole trial. That's exactly what he's trying to do, what lawyers are allowed to do. And say, oh, they didn't give you this or they gave you that, or we're going to knock your credibility, or you don't have all the information. That's totally fair game. But when you do it and it's just wrong, and then you try to block the correct truth from coming out, that's where it becomes problematic. And that's exactly what it seems like Hank Brennan did here. Why did he have to bring up Dr. Laposada to Dr. Russell? He was definitely trying to imply that they had differing opinions. That's what I thought listening to it.
And the Commonwealth has taken advantage of that. The Commonwealth's questioning of Dr. Russell about Dr. Laposada and a report and her opinions about dog bite wounds specifically was deliberate, and it left the jury with an open question. We know they consulted her. We know it was about dog bites. This is how the jurors are thinking about it now. We know they consulted her. We know it was about dog bites. They hid the report from Dr. Russell because they didn't want her to know about it.
By the way, yesterday when I said, we don't know if the jury thinks this, when lawyers make arguments and they want to really drive it home to a judge to get them to see it their way and to make the decision and to make sure we don't have this problem with the jury, they might be a little hyperbolic. They're explaining worst case scenario. So he's like, Judge, the jury's looking over there like they can't trust us. We're hiding reports from Dr. Russell. He doesn't actually mean the jury is thinking that. He means if the jury is thinking that, we better correct it. And if you don't let us correct it, Judge, that's reversible error. Karen Reed has constitutional rights. So when we explain something to the judge, we're like, Judge, this is what the jury's thinking. They're thinking the worst of us. We have to fix that. And whether or not that's true, we don't know because we don't actually know what a juror is thinking. But that's the proper way to make the argument. That's the proper way to protect the record, because if it comes back a guilty verdict, you never know which one individual instance created that problem. And if it's this, we better fix it because this is wrong. And this is not how things are supposed to be done in the criminal justice system.
Must be harmful to defense. Now we've got Dr. Laposada on the stand. Her credentials are peerless, absolutely peerless. They've got possibly the most qualified medical examiner in the country, certainly on the Eastern Seaboard, right in front of them about 6 feet away. And the defense is not going to ask a single question about her opinions concerning dog bites when she reviewed the entire autopsy. How is the jury going to conceive that? How is that going to land with them? The answer is they're going to think, they have no choice but to think, the only reasonable explanation is if Dr. Laposada's opinion helped the defense, they would ask her. If they don't ask her, it's because whatever Dr. Laposada says about that right arm and those wounds, it's got to be harmful to the defense. They would.
And guess what? Sometimes that happens with evidentiary issues and evidentiary rulings by the court. So it's like, oh, well, we didn't get to ask her, so they're going to think negatively. Well, if you made it seem like she was going to be able to testify and it turns out she didn't have the credentials and she wasn't allowed to, that's on you. But this isn't on them. Hank Brennan opened this door. Hank Brennan asked the questions. Hank Brennan created the side-eye look like, why aren't you guys asking Laposada? If you asked Russell and Russell wanted to hear what Laposada had to say, why aren't you telling us what Laposada had to say? Hank Brennan's kind of created that theory in the jurors' minds, and it's the court's job and the defense's job to make sure to set the record straight.
Would absolutely ask the question. So the Commonwealth got to have it both ways. They got to ask Dr. Russell about Dr. Laposada and imply that Dr. Laposada had opinions about dog bite wounds. And then they have it the other way, which is, let's ask the court if she will exclude Dr. Laposada from testifying about the very issue that they brought up in front of Dr. Russell. That cannot stand. That it reasonably ensures that the jury will misrepresent or misunderstand the import of why we're not asking Dr. Laposada about her expert opinion, especially as it specifically pertains to dog bite wounds.
So then he goes into her resume, which is very long and very good. And he repeats his argument kind of in summation. Then Brennan gets up and says, their theme is repetition and using witnesses to vouch for themselves and others. Dr. Russell promoted herself as the only expert that could ever do this. And then we figure out where Brennan was going. He was trying to use Russell to discredit Laposada, saying, you're the only one, right, Dr. Russell? Meaning Dr. Laposada is not the one, but that's not how the questions came out. That's not how the back and forth sounded. I definitely didn't get that from his questions. I don't know if you did. He definitely breached the subject of what did Dr. Laposada think about this being a dog bite injury versus Dr. Russell. Dr. Russell was interested. All that happened in front of the jury. In my opinion, Brennan very obviously opened the door to that. After his argument, Jackson gets up again, and we have some fireworks between Brennan and Jackson here.
Right. Two things stand out about that speech. Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse me.
No, I'm not going to.
So
Oh boy. Somebody texted me and was like, this is like the ASAP Rocky trial now. He's like, Brennan literally said this. He's like, I did not say that. Jackson's like, excuse me. He's like, I will not excuse you. Usually they've been professional. They sit down, they let each side make their arguments, even if they're taking personal shots at each other. Brennan wasn't going to stand for this. And the judge is like, children, relax. But this is how you know it's getting under Brennan's skin at this point. And frankly, how much misconduct can somebody be accused of before it starts to stick?
Stand out. I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse me.
No, I'm not going to.
So I heard what Mr. Brennan said. You don't need to tell me what Mr. Brennan said, but go ahead to
How
your
about if I quote
argument.
his words?
Yeah, I do need to tell you what he said, Judge. If he's wrong or if I have a transcript, I'm going to tell you his words. Like, what do you mean? Yes, that's not the appropriate response by a judge. A judge is, you two don't talk to each other. You talk to me, and Mr. Brennan, sit down. It's Mr. Jackson's turn. When Mr. Jackson's done, you can stand up and have your turn. We don't like it. Lawyers argue for a living, right? We're very argumentative. We love confrontation. We want to battle it out. And unless a judge makes us sit there and wait our turn, we will talk at a turn. That's what the judge is for. Both sides. When the defense stands up, the judge should say, sit down, it is not your turn. Have some respect. Let Mr. I don't care how pissed off you are about what Mr. Brennan's saying. I don't care if you think he's lying. Let him finish his argument. Then I will give you your chance to respond. This is a profession of ethics. We're supposed to be professional. Let's act it.
That question. And so you think of all those forensic pathologists, medical examiners, and you think qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites. The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. Laposada? Those were his words.
And I get what Brennan's saying, that he was actually trying to discredit Laposada, and I get that now. But the way it came out, there's no really other way to think about it than he was trying to discredit them with each other or make it seem like they did not agree with each other.
Then he goes on, I think he also just said that he did not elicit information about other individuals, including Dr. Sheridan or anybody else. Question by Mr. Brennan. Were you ever told what other people's opinions might be regarding those photographs? That's the question that she was answering when she said, quote, I'm aware that there was a Dr. Sheridan involved in the previous proceeding, and he believed that those were consistent with dog bites. That was in relation or in response to Mr. Brennan's specific question. She didn't just elicit that. She didn't volunteer it. She said it because he asked her. And that was all by design. The entire thing has been by design. He elicited the information suggesting that Dr. Laposada was being hidden from Dr. Russell because her opinion would harm the defense. He left that with her on purpose, then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. Laposada to talk about the very dog bite wounds that I asked Dr. Russell about. That,
to me, this seemed like something should have been an easy answer for Judge Cannoni. Of course, it was not. We are going to jump back in with her decision on this motion.
Not going to allow Dr. Laposada to testify regarding dog bites.
So she says denied. But guess what? She has something for the defense.
Your rights are saved. I'm going to give an instruction regarding burden shifting.
Oh, big deal. Like the jury's going to understand what that means. Like, that's not going to help. But like a good lawyer, and by the way, if you remember last trial when we were talking about the jury instructions or the mistrial and how the defense did not get the opportunity to be heard, do you think Judge Cannoni wants anybody to speak right now? No. She's made her decision. She's considered it. She's heard the arguments. Jackson got to go multiple times, but Jackson stands up. He's going to make his argument. He's going to make his record, and he's going to win because of it, because that's what great lawyers do. And that's why I will stand by the fact that the defense was okay with the mistrial before. But right now, Jackson's going to stand up, and he is going to fight for his client, and he's 100% right, and he gets just enough. He gets just enough to do what I think they needed to do with Dr. Laposada with regards to an animal injury or bite. Listen to the way that he does it. You keep pushing. If you're a lawyer, you try to find different ways to make it work. You negotiate. But like I was saying, Alessi, kind of gave her that out with the instruction. Jackson didn't. He asked for everything. Once she says no, now he's going to ask for something simpler.
Okay. So
I think it's outrageous. I think the conduct is outrageous.
He said, I think it's outrageous. And I think he's saying Brennan's conduct is outrageous.
And I don't think that the jury instruction can do anything except bring the point home again.
okay.
But if the court is not willing to allow her to testify to her full opinion to reasonably expect service, can she at least testify that she reviewed the arm, look at the arm, that's consistent with an animal? Can we at least split the baby?
I will do that.
I was shocked after she came and just said a hard no. He's like, can we at least split the baby and say consistent with animal injury or whatever he said? And she's like, I'll do that. It's like, that's it. Sometimes you just have to ask again. Sometimes you just have to push. Sometimes saying it's outrageous, the actions that are happening here. She agreed. She did not have to. She already made her bad decision, in my opinion, to not allow it in. But then she allowed it after Jackson pushed more. That was eye-opening to me and surprising to me, but I'm so glad she did it because I think it's appropriate to rebut some of the things Hank Brennan has already laid the foundation for. And I've already said, if she would have kept this out as cumulative, I get it, but not after this argument by Jackson. Brennan has brought it up, cast, a dark shadow over Laposada and Russell. So you have to allow them to fix that. And she does. Great job by Jackson not giving up. You have to have a lot of cojones to stand up and continue to fight even after you've lost. Sometimes judges yell at lawyers when they do this. And they're like, sit down. I've already made my decision. Shut up. But you've got to fight for your client.
I'll allow that. Yes. Over the Commonwealth's objection.
And I hope to have the cross-examiner, because you won't allow a consistent opinion for the dog.
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience, seeing animal bites, this is consistent with what she has seen in an animal bite.
And that will include, I'll come to sidebar before I display anything. That will include.
So that's coming in, which is huge. And the way it comes out is just huge. So Laposada, they already went through her resume. They come back in and she has some very strong opinions. She says the injury to John O'Keefe's eyelid is not consistent with getting hit by a car going 20 miles an hour with the spoiler of this Lexus. She explains what she would expect, the bigger bruise over different parts of the face. Then she explains how after this injury to his head, he wouldn't be able to get up or walk or do anything purposeful, maybe seizure or arm activity, which to me has been consistent with everybody. Hank Brennan crossed her on that as if, I'm pretty sure that's what Dr. Wolf said too, his own doctor. Pattern injuries can be very important in investigations. The pattern of this head injury for John O'Keefe was on a ridge and not smooth ledge or edge, not the pavement or the frozen ground. That would be more of a starfish type injury. That's interesting to me. Or maybe star. I don't know why I said starfish. She also said, this is not hypothermia. The dead body can cool with the environment. She discusses the Wisniewski spots, things like that, but she is clear he did not die from hypothermia. She talks about the Lucas machine, how that can leave some marks on bodies. But if it was hypothermia, she would absolutely expect to see frostbite, which to me is another logical argument. And when you can use logic, that is incredibly important. And she's going to use logic to connect these things and how a jury probably sees it and would think. Like, I'm not a doctor. I don't know like exactly when it's hypothermia, when it's not, when frostbite starts, when it doesn't. But frostbite and hypothermia going together for a body out in the snow for hours and hours makes logical sense to me, right? And as lawyers, whenever you're on the side of logic and common sense, usually that's a good side to be on. The cause of death was the skull fracture and the brain injury. Then they get in to the arm injuries and the portion that we just listened to that was so incredibly important to make sure she could get into this.
At the postmortem examination, by certain things, then you're able to put together a sequence of events that happened to the body prior to death.
She's explaining how patterns help you identify what caused injuries. And obviously we're talking about the arm now.
What role do photographs play in a forensic medical examiner reviewing the medical evidence and coming to opinions and conclusions? How important are photographs?
Oh, those are huge. It's standard practice to always document at the postmortem examination important findings with photography.
Were the photos in Mr. O'Keefe's case useful in coming to opinions and conclusions concerning his injuries altogether?
Yes.
What about the injuries to his right arm?
Yes, those photographs are very important to understand those injuries.
Do you believe that there's a patterned injury on Mr. O'Keefe's right arm?
Yes, there is a pattern injury there.
Have you ever seen, in your experience, either being taught or teaching, patterned injuries as they relate to animal wounds, generally?
Oh, absolutely. Very common.
Do animal wounds include both claws and teeth, dentin?
Yes.
So bite marks and claw marks might be two.
To me, it doesn't matter at all whether they say dog or animal. Like, how much more effective is this if he says dog? The jury knows exactly what they're talking about. So this splitting of the baby, to me, was a huge victory for the defense. And it was only because Jackson pushed again. I mean, I thought this was huge. I saw no difference or distinction in the fact that they had to say animal versus dog. You guys tell me, did you find a big distinction? Like, do you think the jury's going to notice that?
Different types of patterned wounds that you may see in your evaluation, just in general?
Correct, because when an animal approaches the body, there may be damage from the claws and also from the mouth.
Also, she did a great job of remembering to only say animal and not dog.
Do you expect to see
They did talk canine, like the type of teeth, but she didn't say dog.
punctate wounds as well as linear abrasions?
Yes,
Do you expect to see certain bite patterns as well?
yes.
What types of injuries, let's talk about animals in general, what types of injuries do animals produce on the skin of human beings?
Well, animals can produce, if you're talking about, mammals, can produce injuries from their claws, where you get parallel scrapes of the skin from the claws applied to the skin, or you can see a pattern from the jaw configuration of the animal. And most animals that attack or get in contact with the body have canines. So there's two canines on either side that make paired marks, and that would be called a pattern injury. So it makes parallel sort of gouges, and as the canines move in a horizontal pattern or a vertical pattern, the space between them can change. The other thing you see in
I mean, this is so much clearer and easier to follow than the first trial. That the defense is basically proving this came from a dog and proving that even in the absence of a dog, it did not happen from a car. Like, this is, I don't know if I'm a little shell shocked from the first trial, but the more I listen to this doctor in conjunction with everybody else we've heard knowing Wrenchler's coming, I feel like they should be more confident about a not guilty verdict this time than last time.
animal bite is you see not only the canine,
And it's like, no Proctor, no Higgins, no whatever. Does it matter if it was a dog? Do those people matter is what I'm saying. Do those people matter if they can prove it was a dog? Or at least that it's reasonable that it was a dog? Do those people matter if they can prove it wasn't a car? Or at least it's reasonable that it wasn't a car? They've done so much more than that. It's wild to me the way this trial has gone and thinking how we're here.
lines that come out, but depending on how the jaw is applied to the body, you can have little dot-like imprints in sort of a U-shaped pattern, which are from the incisors, the little incisors of the animal. So you look for punctures, you look for paired gouges, which would be the canines, and then you look for arced patterns of little dots, which can be the application of the incisors of an animal bite.
What is an incised wound?
An incised wound is a wound due to cutting from a sharp object.
Would you expect to see incised wounds from an animal bite or claw marks?
No, they don't cause, they're not like knife wounds. They cause more of a scraping injury.
Do you see the injuries that you're looking at in Exhibit 167, are these more consistent with incised wounds or the scraping abrasions that you just talked about?
Sustained.
Were you able to determine from your review of the medical records whether the injuries that you see on Mr. O'Keefe's right arm were pre-mortem or post-mortem?
They were, oh yes, I can determine that. They were inflicted prior to death.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm is consistent with an animal bite or claw marks?
Yes, it is, very much.
Thank you. You can take.
It's pretty cut and dry, right? Like if they were the prosecutors, I'd be like, the defendant's in trouble. They're proving this case. She said it would look very different if wolves came up or something after death. But then just a couple minutes later, literally just a couple minutes later, they start talking about what you would expect to see in a motor vehicle accident, a car versus pedestrian. What would those injuries look like? And we've heard this again. A lot of this feels cumulative to Dr. Russell, but it's just so good to drive it home.
We talked about the theme and theory of differential diagnosis, correct?
Yes.
How does engaging in the process of differential,
So that's just what this considered. Think of absolutely.
tell me about, well, let me ask it this way. Did you come to an opinion or conclusion as to whether or not Mr. O'Keefe's injuries as a whole were produced by a motor vehicle pedestrian incident?
Sustained.
This is after She said on her resume hundreds of times she's treated people with car accident injuries, pedestrian injuries. Sometimes she knew it was a car accident when they came in. Sometimes she didn't.
You indicated that you've done thousands of autopsies yourself, correct?
Yes,
And you've supervised many times more than that.
correct.
How many of those autopsies that you've performed or supervised have involved motor vehicle incidents?
Now, hundreds.
How many of those hundreds have involved motor vehicle pedestrian incidents?
Almost as many.
Have you performed autopsies specifically on individuals known to be hit by vehicles?
Yes,
Have you performed autopsies on individuals believed to be hit by vehicles?
yes,
Have you engaged in differential diagnosis and inferential thinking in terms of developing an opinion or conclusion to a medical certainty about whether or not the injuries that you see on a decedent are consistent or inconsistent with a motor vehicle pedestrian incident?
yes, that's part of what we figure out as a forensic pathologist.
Did you do that in this case?
Yes, I,
Sustained.
What are some of the injuries that you would expect generally to exist?
This is huge to me because, again, common sense and my life experience, she's right.
If a pedestrian is hit by a motor vehicle at speed, not 1-2 miles an hour, let's say 20 plus miles an hour.
yes, one of the things you see is a pedestrian is, standing upright and is impacted by this blunt object of a automobile or a van or SUV. And what you see first most is the tissue is crushed where the projections of the vehicle impact the tissue. And when you crush the tissue, that gives you a bruise. So that's the first part of the pattern of impact.
That doesn't seem too outlandish, right? Can we expect some bruises if you get hit by a car at 25 miles an hour?
It crushes the tissue. It gives you a bruise because it breaks the blood vessels underneath the skin. And then depending on how much more force is applied, the skin can break.
So I'm going to strike that. Next question, Mr. Jackson.
In addition to bruising, what else might you expect?
Which is similar to the problem of the defense trying to prove the third-party culprit, big fight, punched in the eyes. Seems like they've kind of abandoned that and have agreed that a lot of that pooling of the eyes is from ecchymosis or whatever it's called, where the blood pools. They've abandoned things like that to me were just like, gosh, I don't know. I would think it might look different if he was, beat up versus, falling in the garage. I think that's a better theory. Either pushed, accidental, whatever. It's a better theory. They don't have to prove it. They just have to prove it was not. They don't have to prove anything, but they're trying to prove it was not a car. It was an animal. I mean, if I was going to grade the theories, just the defense theories, trial number 1, it would have been about a 78. Trial number 2, it's like a 95. The way they have honed in and focused and called their experts on what is incredibly important to highlight this reasonable doubt, so much better this time around.
To find an individual who's been struck by a vehicle at speed.
So let's come over to sidebar.
I'm going to skip this sidebar here and we'll come back afterwards.
May I inquire?
Yes.
I forgot where I left off, so I'm just going to pick up.
Okay.
As best my memory can serve me. It has been suggested that Mr. O'Keefe's right arm, Doctor, was injured by contact with the right rear taillight of Miss Reed's 2021 Lexus LX570.
No, I'm allowing that in.
Thank you. As Mr. O'Keefe, it was
He
struck
hasn't allowed that question in a lot, so they must have just discussed it at sidebar.
as Mr. O'Keefe was standing and the Lexus backed into him. That was a postulate put forward. I want to find out from you, do you agree with that?
Well, that's something to think about.
So,
Oh, I'm sorry.
yes, I'm going to strike that question and answer.
Let me ask it a different way. Let me ask it a different question. Do Mr. O'Keefe's pattern injuries on his right arm, do they correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
Why do you say that?
No, not at all.
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so I'm going to strike that, and let's see you at sidebar.
Ouch. It's like, how do you know it's not from a car? Because I know it was from an animal. That was their answer. Then we start talking about didn't have injuries to the lower extremities, and we start talking about x-rays, folks. X-rays. We have a long break, and when we get back, we are talking x-rays. So let me see here. I think this is it. And let me just tell, well, let's listen and then I'll tell you my thought when I found this out and almost fell out of my chair while I was working and heard this today.
Yes. Miss, we need that mark.
The
By the way, he asked her before the break, what's the point of x-rays? Well, they show fractures and defects in the body. And if you remember, Wrenchler, and I believe Hank Brennan has elicited on other witnesses, there were no x-rays of the arm, so we don't really know. We can't confirm there was no fractures. People just said there was no fractures. And I cannot figure out for the life of me, except that a lot's going on, right? Why didn't the defense bring this up earlier? How does the defense not know that there were these x-rays? How did they not impeach Wrenchler with it immediately and say, brother, you're dead wrong? How do you miss this? How do you make this such a big part of your opinion and you miss this, that there were x-rays? But they didn't until now. And I would think the jury's jaws got to drop when they hear, oh, there actually were x-rays. And they actually confirm no fractures. And I'd be willing to bet when Wrenchler comes up on rebuttal, that's going to be part. Now, Hank Brennan may try to hit it on direct, being like, hey, have you ever seen these x-rays? No. Well, if you saw that there's no fractures, does that change your opinion? No, it doesn't change my opinion. He's got to try to lessen that blow because I think it's going to be hammered on cross. But let's hear how the doctor brings it out and what the jury thinks when they hear about these x-rays.
I did.
What were the x-rays of?
The x-rays were taken of Mr. O'Keefe at the medical examiner's office, and they were x-rays of his chest, his arms, and his legs.
When she said arms, I was like, come again?
Did you specifically review x-rays of his right appendage? Hand, forearm, arm?
Yes, they were included in the x-rays.
Have you seen x-rays before?
Oh, many times.
How many times?
Thousands, probably.
Is part of your job to review x-rays?
Oh,
To make a
absolutely.
determination of whether or not they indicate broken bones, fractures, hairline fractures, things of that nature?
Yes, it's part of the medical legal autopsy to study the x-rays of the deceased.
Yeah, we were all like, I feel like they do that. Why didn't they do that here? I mean, some of us were saying like another knock on the Commonwealth investigation. They didn't even do the x-rays. Turns out they did.
It's done in the ordinary course of being a forensic pathologist, is that right?
Yes,
Are you trained on how to read x-rays?
yes,
You have to be a radiologist to read an x-ray as a medical doctor?
no,
Medical doctors do that all the time, correct?
yes, it's part of general medical training.
And is it also part of specialized training for forensic pathologists?
It falls under the rubric of general radiology that a doctor knows. There are some specialized areas in forensic where you have to understand like decompositional changes that you can see on an x-ray that aren't something that you would see in a clinical setting.
Taking the appendage one item at a time, did you look at Mr. O'Keefe's x-rays of Mr. O'Keefe's right hand?
Yes,
Did you see any defect in bones of the right hand?
no bony defects, and the tissue was normal.
Did you take a look at the x-ray of Mr.
And the tissue was normal. Now, probably an MRI is going to be better for soft tissue than an x-ray. Not probably, it definitely is, but this is what she's testifying to. Is Brennan going to have anybody rebut that and be like, well, no, x-rays are better for the bone and the hard structures. They didn't do MRIs or CAT scans of his arm. That could have shown swelling or bruising under the skin or whatever. But this is the testimony the jury's hearing.
His right arm?
Yes,
Did you notice any defects at all in the bones in the right arm?
no, the bones in the right arm were intact.
No breaks,
Correct, no breaks.
fractures, hairline fractures?
No,
Did you look at the upper arm x-ray of Mr. O'Keefe?
yes,
Did you note any defects in the bone structure of Mr. O'Keefe's upper arm?
no, the bones were 100% intact.
No breaks, fractures, hairline fractures?
Correct, none of those.
Was there any indication in your mind, based on your review of those three x-rays, the hand, forearm, the arm, that arm had suffered any kind of bone trauma at all?
Sustained.
Was there any indication, based on your review, your expert opinion, that his arm had been broken, fractured?
No, the bones were intact. No breakage, no fractures.
Thank you.
That's what Jackson, I think that's what he ended on.
Okay, thank you.
Yes, that's what he ends on. Pretty strong point to end on, if you ask me. Pretty strong finish there on the direct for Jackson. Then Brennan gets up and starts his cross. Head injury is being thrust backwards. How fast? Medium to hard. How hard is medium to hard? To me, it was kind of a confusing waste of time, but he was using her language. She says she doesn't know the amount of force, but it was significant. He's going to try to say, obviously, that car hitting you, you hitting the ground, that transfer of force is significant. I get that. He argues with her about the fact that she's not a neurologist or a neurosurgeon. Then at the same time asks about what steps brain surgeons make in taking life-saving measures. I don't know. I don't really get where he was going with that. He's trying to prove also that John O'Keefe could have lived for a little bit afterwards. And she's like, no, I don't think so. He mentions an article Dr. Wolf wrote and gets into this line of questioning. And I really think there was a couple times on this cross where she kind of smashed Brennan and was like, no, that's not it. And we're going to listen to a couple of them.
That's not the case we have here.
Isaac Wolf on clivus fractures.
No.
Have you read any studies on clivus fractures?
Clivus fractures? Yes, I understand what clivus fractures are. It's a part of the base of the skull.
Okay.
And
And
it
have
depends.
you,
Okay, go ahead.
please, did you want to?
No,
say?
you go ahead.
Oh, I'm sorry. Have you read any studies that tell you with the proper treatment, despite these potentially catastrophic injuries, that 1/3 of patients can survive?
No, but that's not the case we have here.
And so in
Kept trying to say he could have survived for longer. Somebody could have helped him. Somebody could have saved him. And she kept saying, yeah, under certain circumstances, but not the injury we had here, not the circumstances we had here. And she very calmly is like, if you're going to argue medicine with me, bro, it's not going to go well for you.
In this case, I asked if you had any objective criteria. You don't have any objective criteria about the progress of Mr. O'Keefe's wound that can be a basis for you to conclude that he would have died in 15 minutes. Isn't that fair to say?
No, I understand what happens to the brain when it gets that sort of injury. I understand the time course and the physiology. I've seen hundreds of individuals who've had brain injuries. Some survive for a longer period, some die earlier, and it depends on the amount of force and the amount of brain swelling. And in Mr. O'Keefe's case, we had the massive skull fractures of the base of the brain and immediate swelling and subarachnoid and subdural. So he had a large force applied to his head, which caused the brain swelling and the herniate and the progression of the brain stem down through the foramen magnum that stopped the brain. It was a very forceful impact.
You examined his brain.
It's like, that sounds like it makes sense. I don't know, a lot of big words. I didn't necessarily know what they mean, but just for a dumb lawyer, it kind of makes sense to me. I don't know. Then they were talking about how long it takes for the blood to pool around the eyes. Brennan wants it to be 1 to 2 hours. She's like, no, I've seen it much quicker than that. She doesn't think the frozen ground could have caused this injury. He's like, well, you didn't go look at the scene. Were there rocks? You don't know if there was rocks. You don't know if there was gravel. You don't know if it was just grass. She's like, it was a flat surface covered with grass. He's like, well, you weren't out there. And she's like, no, I did not go out to the scene. And then again, he asks these questions that to me open the door for her to talk about the fact that she thinks it was an animal injury.
Hit a person in the back of the head with enough force, with like a hammer, for example. That could leave a depressed skull fracture, couldn't it?
Certainly, you can hit somebody on the head with a hammer and cause the fracture, and then the continued force will move that fracture into the brain.
There was no depressed skull fracture in this case, was there?
Correct.
You gave some opinions today about you gave some opinions about wounds on Mr. O'Keefe's arm. I'd like to talk to you a little bit about that.
Sure.
Could we have that photo brought up, please? Do you see all of those superficial abrasions?
Yes, I see patterned injuries.
Right. Would you agree that they're superficial abrasions?
Yes, they go along the skin surface.
How many punctures would you identify in that photograph?
Let's see, there may be some punctures like around the elbow, consistent with the teeth puncturing. Most of them are the teeth scraping along the skin.
I'm not going to ask you what you believe the cause was. I'm going to ask you just about the wound.
He's like, don't tell me what you think the cause was. I get that you think it was an animal. Just tell me about the wounds. Then they're going to go back and forth and argue about puncture versus scratch here. And then she lands potentially the haymaker of all haymakers.
Of the skin, isn't it?
Yeah, a point-like penetration.
A puncture has a very specific medical meaning, doesn't it?
Yes, it's a point-like penetration of the skin.
And according to you, there are many punctures in that wound.
Yes, I can see 1, 2, 3, 4, 6 or 7.
Can medical professionals disagree on opinions about wounds and causes?
I suppose they can.
You also gave some opinions that you did not believe that Mr. O'Keefe's scratches were caused by having some impact with broken pieces of plastic or glass, correct?
Correct. They weren't caused by that.
She's like, correct. They weren't caused by that. Like very confidently. Now just wait, because there are some issues coming later that Brennan has up his sleeve that are going to be used at cross later, but he is not doing any damage to this witness so far in cross.
Broken plastic or glass, correct?
Correct. They weren't caused by that.
Broken plastic or glass can cause a number of different angled wounds, can it?
It causes an array of irregular, random injuries.
It can have infinite different patterns, couldn't it?
Could.
There's nothing to hold a wound from a broken shard to be north or south, east and west. It all depends on how the force is impacted on the body, true?
I'm not quite clear on your
Okay,
question.
I'll try to do better. When you're talking about shards of broken glass or broken plastic, there's no set direction that they may cut somebody, is there?
Well, it would depend on the case and how those occurred.
It can happen in many different forms as far as depth, yes?
Well, anything's possible.
How about length?
What about length?
Wouldn't that change? Couldn't that change depending on how the injury occurred, the length of the wound?
Sure.
And in this case, you talked about your opinions of injury relative to a motor vehicle, didn't you?
That was something I considered.
It's something you considered. Did you know much about the details of the motor vehicle in this case?
Yes.
When you considered your differential diagnosis, did you consider whether there was any DNA on the vehicle?
I didn't look at any of that.
I'm sorry?
I did not look at any DNA.
Did you know if there was any hair on the vehicle?
I don't know.
Did you consider the scene itself where there may have been a debris field? Did you take a look at the debris field in this case?
I know there were photographs of various pieces of plastic around the area where the body was found.
And do you remember where those pieces were found?
Somewhat, yes.
Did you have an opportunity to consider other evidence like a shoe in the area near where Mr. O'Keefe was found?
I know one shoe was on his foot at the hospital, the other was at the scene.
Do you know if his hat stayed with him after he landed on the ground?
The hat was in the area where his body was found.
Did you take a look at his pants, the back of his pants?
I looked at that, yes.
What did you see when you saw the back of his pants?
Well, because he had bled from the back of his injury and he was on a hospital gurney, some of that blood came down, so some of the blood was on the back of his pants.
Did you see anything else other than blood on the back of his pants?
I don't remember.
I'm sorry?
I don't remember if I saw anything else.
Did you look, when you were doing your differential diagnosis, did you look at any evidence other than physical evidence? Did you look at any data evidence?
I don't know what you mean, data.
Like data you'd find on
Like, I don't know what you mean, data. Here we go.
a cell phone?
No,
Did you look at any of the data evidence from the defendant's Lexus?
no, other than looking at the contours of the back to see if it had impacted Mr. O'Keefe.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
I would love to know. That was like a shocker type moment. And again, when I heard it, I had to stop what I was doing and go look and watch it. That is the type of moment jurors usually react to. And if they hate the defense and they hate Karen Reed and they think she hit her cop boyfriend with the car, they'd be like, this hired gun. But if they think she didn't and they don't like Hank Brennan, they'd be like, so I wonder what the juror's reaction was to that comment right there, because she said it loud and proud. And I didn't look at it because it didn't happen. And I would love to know how they reacted. And if they reacted favorably to that comment, ooh, I'd be so confident as the defense. Let's go. Let's do this closing argument. Let's keep fighting. But if they had a negative reaction to it, might be a little nervous.
Doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Okay. So you didn't care to know anything about the car or the data in the car because you had already formed your opinion?
it did not hit him, so it was not relevant to my opinion.
Is
I
that a
could,
different way?
by looking at the body, I could tell that there was no evidence of impact with a vehicle.
Is that
So
a-
whether the vehicle was going slow or fast is not relevant.
and so
Yikes, that's just like gutting a fish. Oh, that's gotta hurt. I mean, that's brutal. There's nothing you can do because you're asking the questions. You can't object and be like, Judge, she's going too far into it.
you didn't try to get any information about the speed
You
of
notice
the
how he
vehicle?
didn't really get snarky with her? And I'm kind of surprised based on what we're going to talk about in a second, the information he has that he wants to go in on her about. I'm surprised he didn't have a little snark there.
There was no evidence of impact with a vehicle.
Is that
So
a-
whether the vehicle was going slow or fast is not relevant.
and so you didn't try to get any information about the speed of the vehicle? It was totally irrelevant to you?
Correct.
And did you also disregard, well, let me ask you, do you ever look at statements?
So he talks about witness statements by the defendant. Didn't really get much there out of her. But when they were on lunch break, he says, Judge, I want to bring something to your attention. I would like to cross-examine this defense expert on basically her credibility. That there were reports showing 1,500 problems or bodies that didn't have proper reports or the reports never got done, proof of negligence or malfeasance on her part. She resigned shortly after these accusations happened and these findings were made. She screwed up in some of the high-profile cases that they talked in detail about to talk about what a great expert she is. And they call her when there are difficult things that need to be proven and figured out. Well, she screwed a lot of those up. She was denied the ability to be an accident reconstructionist. And she was called a hired gun and not credible by another judge. Now, if you want my opinion, a lot of that is fair game. Probably not the accident reconstruction stuff. We'll talk about what Judge Cannoni said. But to me, that is, you're allowed to hit her credibility. If she screwed up on that high-profile case, you should be allowed to say, if there are actual findings, if she was found to be incompetent at her job, I don't know what they actually are. And I am no longer in the camp of just giving Hank Brennan the benefit of the doubt when he says something exists, okay? So I apologize, but the lack of x-rays and the holes on the sweatshirt in the last couple of days, to me, I want to see it. I want to look at it myself. I'm not just going to assume what any lawyer says anymore in this case is what it purports to be or that it is true. But he says he has, but I also am going to rely on the lawyers to point it out with each other. The defense needs to point out if Hank Brennan makes a material misrepresentation. That's part of their job. But if he actually has findings in these reports that say she screwed up at her job or screwed up some of these high-profile cases, I think he should be allowed to ask her about it. I think that's fair game. Jackson gets up and argues this was political. She wanted to do more quality control. The new boss didn't want to. She refused to sacrifice quality for speed, and she resigned. And he also mentions Brennan's used her a bunch of times. And Brennan gets up and is like, yeah, I haven't used her as an expert 4 or 5 times, just a few times. It's like, I love when that happens. And that happens more than you think, where lawyers use the same experts or are cross-examined. I have absolutely cross-examined and hammered experts that I have also used. Absolutely. And sometimes when you have a good expert that usually testifies for the defense and testifies for you, that can be really good in civil cases because they're like, yeah, we like that guy. And if he says it, we'll believe him. Or it's harder for them to cross-examine a witness they've spent $3 million on the last 3 years. The judge ends up saying that the backlog or issues with the 1,500 reports is allowed in. The nightclub fire issue is also allowed in, but nothing else. I haven't seen that yet because we're on lunch break when I'm recording this. So we'll kind of see how this really comes in and how they're allowed to impeach her on it. I think they should be able to. I think they will. But I think a lot of damage has already been done with this witness. And if I was Brennan, I would have started with this, not ended with it. Frankly, it might have been the only thing I asked this witness because what he's asked her has not gone well. Then there was another objection to Wrenchler, new things in his report, new things in his PowerPoint. At this point, it seems like they're trying to work out most of it. But I'm going to pause here now for part 1, and I'll be back to talk to you about what happens after lunch in part 2. It'll just be a split second for you, but it'll be a couple hours for me. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.